Well, good morning or good afternoon for some. Welcome to today's SBDX webinar. We have a very special session in store for you today. We will be doing a debrief on the Holmes trial. I am Nancy Easterbrook. I am Executive Director of SBDX. For those of you not familiar with our organization, I encourage you to go to our website, www.sbdx.org, to learn more about our programs and to view some of our past webinars. Today's session will be 1 hour in length. I encourage you to submit your questions via the Q&A feature on Zoom, and we will be recording today's session for later viewing. It's truly a pleasure for me to introduce our speaker for today. Both Dan and I were lucky enough to work with Bob during our time at Stanford Law School, and we're very honored that he is with us today. Robert Weisberg is the Edwin E. Huddleston Jr. Professor of Law, as well as Associate Dean for Curriculum at Stanford Law School. Bob works primarily in the field of criminal justice, writing and teaching in the areas of criminal law, criminal procedure, white-collar crime, and sentencing policy. He also founded and now serves as faculty co-director of the Stanford Criminal Justice Center, which promotes and coordinates research and public policy programs on criminal law and the criminal justice system, including institutional examination of the police and correctional systems. Our moderator for today, Dan Siciliano, is a successful technology CEO, founder, and entrepreneur. He is currently chairman of the board of the Federal Home Loan Bank of San Francisco, chairman of SBDX, board member of the Latino Corporate Directors Education Foundation, and a fellow at Stanford University. Again, thank you for joining us today, and a special thank you to Bob for being our speaker. Dan?
Great, thank you, Nancy. Again, to reiterate, this is really exciting to have just a conversation with Bob Weisberg. He's one of the few folks who would always humor a visit by a young faculty member who wanted to talk about, I don't know, robots that commit crimes, any number of things. So I'm super glad to have him here just to walk us through what our take should be, or maybe what his take is on the Theranos trial, the outcome, and what it maybe means, if we can discern that, for entrepreneurs, investors, and others. So maybe, Bob, with that as a kickoff, maybe give us your take on what transpired with the verdict. Is it something that you expected? I might ask some follow-up questions about specifics, but like, how did this land for you? You thought that this was going to be the case. You're surprised by it. Neither. What's your take?
Thanks, Dan. I may be the proverbial broken clock that's correct twice a day. I say that because the verdict was pretty much what I predicted in this case, but I normally don't have a lot of faith in my ability to predict jury outcomes. As I mentioned to you once, I'm one of the legal geniuses who back in 1995 patiently told lay people that the O.J. Simpson jury could be out for as long as 2 weeks and might deadlock. I was a little off. They acquitted in 10 seconds. But in this case, I kind of thought all along that there'd be a significant number of conviction counts, that they'd focus on the clearest instances of investor fraud, that given the number of counts, it was quite plausible that the jury would be out for a while. And of course, there'd be a lot of tea leaf reading. What is the significance of them being out for 7 days, 8 days, whatever? And the answer I would have given at the time was they're just going through things methodically. And I wouldn't draw any inferences, certainly any inferences that the government was in trouble. So, the number of counts, 4 out of 12, finally, it's almost kind of arbitrary. The point is that I think the prosecution won the gist of its case with the strongest evidence it had. And with all the Sturm und Drang and celebrity melodrama of the case, this was always a very, very straightforward case under very basic principles of federal wire fraud law. It didn't have any really complicated legal issues in it. It was all about the facts. The facts were pretty strong, and therefore the verdict just makes a lot of sense.
So you maybe anticipated a little bit my next question, which is a lot of people have observed that the justice served is mainly justice to what many would argue is a class of individuals who are in a pretty good position to protect themselves, who have a pattern of, things they should do. And maybe this particular class may not have done as much of that as they should have in the form of due diligence. And yet the other parties in this story, perhaps patients, people who patronize or were, tried to get the benefits of the product that turns out not to work and to be fraudulent, are kind of a side note, if not mentioned at all. And just looking at it without much interpretation, that surprised a lot of people. And I think you might have just hinted out the why, but can you expand on that? Like, that was my take too a little bit, which was, wait, okay, the 4 counts are about the folks who should have known better or maybe should have known better. And the innocent parties, what about them? Is there a view to that?
It's a legitimate concern. And one thing I'd note is that it's possible that in condemning Holmes on the fraud investor counts, the juries, well, they were mainly motivated by the strength of the proof, but they were, I think, also motivated by their awareness that this particular fraud raised risks of harm to indeed, unprotected, low-resourced parties, most obviously patients. And therefore, it's not as if they were irrelevant to the case. It was sort of baked into the nature of the case. That is to say, the concern that this fraud was particularly dangerous because it wasn't about abstract issues of finance. It was about a product that was a healthcare product. But getting back to why the only vindicated claimants, if you were, claimants or complainants, were the investors. We just get back to the nature of fraud law. There could have, in theory, been other charges under state law or federal law that involved something more specific about healthcare. Heck, there could have been, I'll make something up here, assault charges. If it, you could argue that they put something into the stream of commerce that caused physical harm. And if somebody had died, who knows? I'm just, hypothesizing here, homicide charges if somebody had died. But the way the feds handle this, and this was the clearest instance, is fraud law, which again isn't very complicated. Yes, you have to use the wires to get federal jurisdiction, but that's not very hard. And the rest of it is simply a demonstrably false representation of facts which have a material influence in causing someone to suffer financial detriment. It's a scheme to defraud in order to take the property of another. And therefore, it was the directness and the clarity of the communication relationship between Holmes and the investors and the easy proof of the causality of financial loss. Whereas with respect to doctors and patients, downstream secondary, tertiary effects, harder to prove specific harm, certainly harder to prove financial harm, given the complexities of health insurance, that could be attributed to her lies.
So, we're assuming that those who are listening in and paying attention have some pretty good backgrounds. We're not going to take a lot of time to delve into the mechanics and the preliminary details. But I do want to ask you something, because you've mentioned it already a couple times. You've emphasized kind of federal, and that implies a distinction from state. And I know there's both the charges themselves, that's different. You already explained that. And then there is, to a certain extent, the way this plays out in terms of the type of prosecutor, the objectives of the Department of Justice. Like what is the relevant takeaway as an observer about what it meant for this to be federal versus state or otherwise? Is that a material difference? Does it imply how these kinds of cases might be handled differently in the future? What can you tell us?
Well, first, many things, including the things she did, could be punished under both federal and state law. She committed fraud in any number of states. I mean, it would have been state jurisdiction, but certainly it would have been provable in California, and it would have been provable in any state where any of the communications between her and the investors occurred. So why is it done under federal law? Nothing precluded state charges. We often see simultaneous federal and state charges, but there's something about complex white-collar cases that brings the feds that makes it much more likely that they'll play a role. First of all, there's the whole issue of, you might say, a role definition. County prosecutors, who prosecute 90+% of the cases in the United States, tend to be most concerned about the crime most people think most viscerally affects them. Street crime, burglaries, robberies, and maybe drug crimes, okay? And they often have very constrained budgets and limited scope of jurisdiction, of course. The federal prosecutors aren't the ones whom the public turns to when they say, I'm afraid of an increase in crime in my neighborhood. I'm afraid of increased crime trends. They have a lot of luxury. They can pick and choose cases. So long as there is federal jurisdiction, they can take the ones they want. And thanks to the incredible breadth of things like the wire or a mail nexus, there's quite a range of cases they can take. They have much more time and money and personnel on hand, especially for the investigative part. And once you get into complex documentation, both paper and digital, the resource constraints on state prosecutors are huge. The feds have the FBI, the most professional, well-resourced police force in the United States, as well as, of course, other agencies of the federal government. Finally, there is a bit of, and this isn't really a legal point, it's kind of a social, psychological, or political point. There's something about the character, the self-defined character of federal prosecutors. They can be very moralistic folks. Well, all prosecutors can be moralistic folks, but if I could attempt an extremely simplistic distinction, okay? Prosecutors at the state level, when they're very arrogant about their role in the world, tend to be the ones who say, I'm protecting the people from the things they are afraid of and legitimately afraid of. I'm protecting them in the most basic sense. By contrast, again, it's something of a caricature, but I think there's some sense in it. When you put on the US attorney role, you are protecting the morals and integrity of society, or fill in certain cliches, which from securities law, the integrity of the market, if you will. They can be very, very moralistic. So you get the combination of the resources, the breadth of jurisdiction, and that kind of self-defining persona, that kind of motivation, which made this case, I think, so irresistible to the feds that it was in effect unavoidable.
That makes sense, and it lays a good backdrop. And I want to ask, we've gotten some really great questions from the audience, so I'll start weaving those in. But directionally, let me tackle a bunch of them with kind of the open-ended question of, can you walk us through what's next, right? So there's a sentencing phase, but there's a lot of misunderstanding about what can be appealed, what is likely to be appealed, and what the time frame is. So could you maybe give us kind of the blocking and tackling of what happens next and what the timing of that is?
Well, all appeals, of course, are essentially complaints that the trial judge did something wrong. Okay. Even a claim that the jury got things wrong really has to be treated as a claim that the judge got things wrong. I say that because a claim that there was insufficient evidence to convict on the conviction counts is unbelievably difficult to win. It's the hardest one to win. And the argument can't be the jury had it wrong, but rather that the jury had it so unbelievably egregiously wrong that no reasonable jury could conceivably have found guilt beyond the reasonable doubt, which means why in the world didn't the judge dismiss the case or issue a directed verdict of acquittal? I'm sure that'll be filed. What the heck? Okay, it's not going to work. Then you'd have to find specific legal rulings made by the judge which detrimentally affected Holmes and where her lawyers objected. There are some evidentiary rulings here, and you'd have to go through the transcript in great detail, and I'm sure some of them will go into an appeal, but I would just say that in comparison to other trials I've seen, I don't think they have much to go on. It goes back to the fact that legally this was not complicated. There weren't complex nuances or unresolved issues of interpretation about the meaning of the wire fraud law. There isn't that much to the meaning of the wire fraud law. Again, it's all in the facts. So the case is obviously going to move to sentencing. And one thing is for sure, if the sentence is more onerous than you might hope for, the sentencing can certainly be appealed. So we don't yet know what they will be to appeal on that. But the federal sentencing guidelines, which many in the audience would know about, are a very complex mixture of the bizarrely formulaic and almost mathematical with a fair amount of judicial discretion. So the sentencing hearing will look a little legalistic, where the prosecutor will cite certain factors enumerated within the sentencing guidelines, almost as if it's like a new mini trial on certain factors. although obviously without the jury present, without any jury at all. And the defense will rebut them in a kind of quasi-trial type procedure. But there will be plenty of opportunity here for her to make essentially moral and emotional appeals about mitigation.
And let me ask, so first of all, time frame for all that. What's the sentencing time frame? How quickly might we expect that to play out?
Sometime in the next few months. I wouldn't be surprised if it didn't get resolved for a few months, because there's a lot of preparation that goes into this. It's not a quick event.
And before we go down the path of asking some questions about the civil versus criminal, the corporate governance versus the diligence, which we'll kind of parse together, I want to ask a few more questions about the sentencing. And I'll first make an admission, which I reserve the right to retract as I learn more, but maybe it's because I'm the dad of a toddler, but I despite having no, sense of forgiveness for her and her behavior, I still have a pang of anxiety and empathy on her behalf when arguably she faces, depending how you count it, a lot of years to a lifetime. And maybe you can comment on the probabilities of that, but she has a toddler and she will go to prison, and if she does, and she will, not have a chance to be with that toddler. Now, mind you, we can also mention the equity issues here, where there are lots of women who arguably face less serious crimes that also happens to. But for this case, I actually have that reaction. And I wonder is that going to play into the way that the sentencing comes down, and what might you guess are the realistic ranges of sentencing, and how should we think about that if we're trying to predict it or understand it?
Well, I think it's a natural human instinct to worry about, the interest of the child here. You mentioned the equity issue, so let's be blunt. The fact is, and indeed it is part of the national scandal about mass incarceration, and particularly about the oddly disproportionate effects of mass incarceration on women, it's that there are thousands of women who are mothers of fairly young children who sit in prison a long, long time. Most of them, of course, in state rather than federal, because that's where most of the imprisonment is. And I simply say, in terms of, the way this, concern is conveyed, is that a very large number of those women were convicted where they were accomplices to men where their culpability, looked relatively, lesser than that of their accomplices. Big issue. And therefore, the government, if it wanted to be quite blunt about it, could say, it could say, well, there's nothing special. We sentence young mothers of young children in the United States all the time. That equity notion may well weigh on Judge Davila's mind. He came from the state system. He's a very thoughtful, socially aware judge. But it can't be a categorical argument against the prison sentence. It just can't be. First of all, there are gender equity issues. In other words, men are fathers, men are parents too, of course. But it's more simply that it's not a formal statutory mitigating circumstance. It is something that can be taken into account, if you will. I had a thought, and when we were talking about this earlier, about an interesting analogy, and this is about a different kind of case, but it may tell us something. And that is, some people in the audience may be aware of what a wired plea bargain is. It has nothing to do with wire fraud. And that is where two accomplices to a crime are given a chance to plead, where each one will have the plea accepted if the other one's plea is accepted. So there's a certain kind of coordination. And the best example of this in the context that's relevant here, the parental context, is the sentencing of Kenneth Fastow, the CFO of Enron. His wife was also charged in Enron crimes. They worked out a plea where, and I may get the numbers wrong, Dan, but you may remember, he pled to a sentence that was going to get him about 10 years. I think he's out by now, but I'm not sure. Okay. As part of a package deal, that's another term for this, whereby she would get, I believe, virtually no prison time at all. Possibly she'd been in jail and she got some time served. Why? Because they had young children. Okay. Now, that's not any kind of legal precedent, but maybe it's a predictor. And what it really says is a judge might be concerned that a child could go parentless and will find ways to protect the child from going parentless. Well, this child will not go parentless if Holmes is in prison. There's another parent, and there are other resources. Her mother obviously is very protective towards her, and so on and so on. Now, that doesn't mean the child factor will be irrelevant, but it just means that it won't be a categorical thing. I can also imagine the judge thinking in terms of a number of years, maybe based on the kind of childcare resources there are, where he's trying to reduce but would not eliminate the issue of the child not having a lot of contact with her mother for a while.
Yeah, no, that makes a lot of sense. And I appreciate the distinction with the Enron Andrew Fastow case, because some at the time criticized it as a strategy to get him to plead, right? Where he was definitely afraid that,
it was.
Under Texas law, the children would be taken into state custody after having no custodial parents.
If you're suggesting that prosecutors do a kind of legalized extortion, yes, that's part of the criminal justice system, alas. But it's just, again, a kind of indicator of, how a judge might think of the parenting issue.
And so with all of that in mind, and I think that's a very helpful, nuanced answer and a pretty human answer. And it's good, the insight you gave us into the judge. Where do you think it's going to come down, plus or minus? Like the potential is actually theoretically quite high, but my understanding is that's unusual to kind of sequentially max out this type of, jury verdict.
Absolutely. Well, okay, let's talk about the theoretical maximum, which only exists in somebody's Platonic theory. 4 counts, 20 years each, 80 years, okay? Not going to happen. There is a grouping formula in the federal sentencing guidelines, which is a kind of presumption that we try to do the equivalent of concurrent sentences for similar counts. I say the equivalent because you can formally sentence her to 4 times 20, and then say that all the 4 sentences should be served concurrently, so it's 20. Or under the grouping approach, you can basically just put them into the Cuisinart and just make it one sentence of 20 years. There's some significance to that difference, but not a huge amount as far as she's concerned. But the 20 years itself is, of course, the statutory maximum, and Congress makes up these maximums, and in this case, made it up many, many decades ago. But the federal sentencing guidelines, of course, are based on the notion that we should kind of normalize sentences around something like what seemed to be an average when the sentencing guidelines were created in the 1980s, and then plus and minus above and below that number based on factors enumerated in the guidelines. And factors will be enumerated. There's certainly going to be one called abuse of trust or abuse of authority. And the major factor, the thing that is most mathematical, still manipulable, is simply the amount of loss. Loss can be defined in various ways. But if we assume that all the money invested by the investors covered by those 4 counts is down the drain, I think we're talking about a little less than $1 billion. I may be wrong.
Yeah, and depending how you add it up, you're plus or minus $1 billion. You could get creative and exceed that threshold, or probably land below.
Now, you could get a lot of years factoring that in, along with a number of other things that go into the sentence in Cuisinart, and it could easily come to 10 to 12 years. Again, individual sentences have no precedential effect on other sentences, but if you think of other major, I'll call them securities law cases. This isn't the securities law charge itself, but it's similar to big financial cases. Bernie Ebbers got, I think, about 20. Correct me if I'm wrong. Obviously, Madoff was off the charts. Roger Rotman, the insider trading convict, I think got about 12 years. Now, again, these cases were all different, but sometimes it's best to step outside all the nuances and ask what the kind of price list is for a fraud of this size. And I think 10 to 12 years is perfectly plausible. But I don't think she's going to get it. First of all, one factor is she has no priors, and that itself is a mathematically calculable factor in the guidelines, but it's 0 in her case. The other is, though, the human factors, if you will. And I have heard guesses ranging from 2 or 3 years to 12 years. Uh, I have no more confidence in my ability to predict the sentence than I had in my ability to predict the verdict, but I got maybe lucky there. So I'm going to go with fewer than 5 years.
Got it. And the one follow-up question before we pivot into kind of some governance, gender, other issues, is along the lines of what interaction do appeals have in terms of delaying, let's assume there's an actual sentence with time to be served, in terms of delaying her incarceration? Is that something that is on the scale of months, or could it be years? And how does that work?
First of all, that's entirely up to the judge. There's really
Okay.
no regulation there. She obviously was allowed out on bail. She hasn't served any time in jail. Ironically, and it just didn't happen in this particular case, and maybe it wasn't feasible at her end, it is sometimes advantageous, oddly enough, for someone to spend a little time in jail in the hopes that the judge will then sort of compromise things by saying, I hereby sentence you to prison time, but I'll give you credit for time served, which means you don't have to go to prison, or you don't have to go very long. And that could even play a role in post-sentencing, pre-appeal resolution time and all that. But I think in a case like this, where there's been, if he hands down a prison sentence, and given the length of time since the charges were filed, I think it's quite likely that the judge will say, well, you're going to go to prison. And that means that even if you have some hope of overturning the charges on appeal, you're going to serve some time for a while.
So, final question before we jump into the governance, and that is both defense and prosecution. Did you see anything that makes you think that they did other than a good to excellent job? Did anything jump out at you like, ooh, that's going to come back to haunt them, or, oh, that was a mistake?
Not on the prosecution side, although again, they had a pretty easy case. They really did. I think their sequencing of witnesses was very effective, just for an interesting pairing. First, get General Mattis on there, okay? Not a sympathetic figure in the sense of, my God, the poor man, he had no way of protecting himself in the world. He's obviously a very powerful figure, but a widely respected figure, very quick and clean, total fraud. Combined with what I think was almost the witness that almost solved the whole case was Mr. Rosendorf, the lab director, who testified about telling Ms. Holmes, it doesn't work, the data is wrong, and reporting that she clearly responded by indicating that she was going to ignore what he said, go to a plan B or something like that. So I think the prosecutor was very, very effective in doing a clean case from the start. I'm not sure if the defense lawyer could have done better. I think they were effective defense lawyers. I think they did a reasonably good job of cross-examining some of the prosecution witnesses on some of the details. They also tried to elicit the idea that some of the investors weren't so naive. There were questions of the timing. It's true that she said X or Y, but isn't it true that you had already committed to an investment before she said X and Y, and it was all noise or something like that. It didn't work. It probably couldn't have worked. The strategy question, but again, I'm not sure if it made any difference. The strategy question had to do with the way she was portrayed personally. Before the trial, they gave out strong indications that she was going to portray herself as entirely enthralled to the manipulations of Mr. Balwani. That although she might appear to have done things intentionally, she had almost no emotional or psychological autonomy because of him. And that was obviously going to be risky. A, people might not believe it. B, it would create inconsistency with the other persona, namely, I am a strong, active, thoughtful entrepreneur, and you folks there need to know how brilliant entrepreneurship works by trial and error. She wound up kind of bringing in both of them. And then a couple of other things. There was I didn't really make that many decisions persona, to go along with the I'm the brilliant entrepreneur risk-taking persona, and I'm also the one who had no emotional autonomy persona. And then she had another kind of half persona when she was cross-examined about very specific lies, undeniable ones, like the misuse of the Pfizer logo on a document. I'm blatant act of fraud as there is. She would confess to the jury. She said, I shouldn't have done that. That was a mistake. I was wrong. Now, it's as if she was where the defense was telling the jury, pick a card, any card, which of these personae will work for you? I don't know if it would have been better for them to have avoid this multiplicity of Holmes personae here. I just don't know. It probably wouldn't have made a difference, but I think that would have been the strategic issue.
Yeah, and that's one of those things that in the law, if you're trained as a lawyer, you grow perhaps too comfortable with this notion of pleading in the alternative. If that one doesn't work for you, let me try this. If that one doesn't work, let me try this, even if there's inconsistencies. I think the average person looks at that and says, listen, you got to pick your story and stick with it. But it's hard to say. And I appreciate the kind of the observation about her persona, which I think we'll get to. But let me switch now to where the majority of questions have gone. And it's at the intersection of what I do and what you do. And so we'll do our best to try to answer this, though I will put a caveat out there, which was, as attendance, built for this particular webinar, we identified the fact that we want to do a lessons learned purely from a board viewpoint around the Theranos case. And we'll do that. So some of these questions I think are not quite yet answerable because we don't have enough data. I'm channeling Dave Larker at the moment at the Rockstar, the Business School, and Joe Grunfest and others, where you don't want to hypothesize too much on anecdote and casual observations. That said, we have a duty to our audience to try to answer some of the questions. So let me do a softball first. And that is, I'm paraphrasing, so the board was involved, some of the board members, every step of the way, from the beginning to the end, as cheerleaders, as follow-on investors, as vanguard to push aside regulators, you name it, they were there and they were an active board, some less so, some more so. Why weren't the board members drawn in criminally? How come they're not criminally culpable? Like, why isn't it like the mafia or the mob? Didn't they conspire? Didn't they stand to benefit? Might they have known? Why isn't that at least on the table and somehow board members not facing criminal charges? We'll draw a line and talk about the civil stuff in a moment, but maybe you can talk to us a little bit about that, both practically and legally, if you like, philosophically.
Legally, it's all about proof of intent, to use an old-fashioned term, which is a bit obsolete, but we could use it here, specific intent. This kind of fraud, now to borrow something from a very different kind of crime, has to be virtually premeditated, if I can use that term. Now, it's interesting that you talk about the board suggesting individual board members as accomplices. Let me come at it from a different angle. To the extent that Theranos still existed as an entity at the time of the trial, could there have been a prosecution of the corporation? The answer is sure, why not? But that's because there's a lot of vicarious responsibility that can be inferred or ascribed when we're talking about principal agent matters and corporate criminal liability. The corporation can be vicariously responsible for the actions of high-level officials. Also, a different take that someone sometimes sees in criminal liability is that the corporation can be liable if other officials were reckless or negligent in allowing the bad thing to happen, even if the bad thing was an intentional act by one person. So that's possible for busting the corporation, but that gets back to your question. I assume the government didn't have sufficient proof, didn't have enough confidence that it could prove truly shared intent, as opposed to maybe what you might otherwise call very, very culpable recklessness or negligence, something that which, yes, could come up in civil cases, but couldn't be, there's no such thing as negligent mail fraud, if you will. There may have also just been logistical and almost more pragmatic problems, and that is you want to make the case against Holmes as the outlier. You're putting down a marker. We have found the most egregious case of investor fraud in decades. We're going to make her an example. Mix that in with somewhat less culpable people, and the prosecutor's message gets blurred a lot. But I think the main thing is proof of intent.
Yeah, and I think that makes a lot of practical sense, right? So a lot of this is the strategy around securing a conviction for the person who was the arguably most egregious bad actor, and to muddy it creates problems. And also my small part of this answer from a corporate governance viewpoint would be that even in a startup enterprise that is venture funded and has what we might think of as relatively active directors, it is the case that some directors were criminally charged. Those happen to be the officers who are executives and directors, right? Namely Elizabeth Holmes. But it is difficult, arguably, for even an active outside director to put their hand in the cookie jar in a way that achieves, Bob, what you described as intent and to create the evidence for that intent. And so that's a lot harder to do as a matter of governance, as a practical matter.
And I would add, by the way, when we're speaking of governance, remember, so much of the strength of the case against her had to do with her own technical people, her own medical people telling her, no, the data isn't there. In other words, you had two levels of confrontation. The confrontation of the exchange between her and investors, very, very direct, whereas the board didn't deal directly with the investors. Second of all, the confrontation that she experienced with the data people, okay? Compare that to what a board does. Board is kind of more macro, more detached entity and all that. You just don't have the case against them in the same way you had against Holmes.
And that's a great segue, actually. So I'm going to ask you a question where I think I actually want your not academic expert in corporate governance answer. Although I will say you've been hanging around enough corporate governance people for long enough and done enough presentations at Directors College that I think you can channel the corporate governance expertise.
Oh, I was hoping you would liberate me from any pretense that I'm a corporate governance expert. But go ahead.
And I think what you are is a expert corporate governance observer, right? So like you
amateur, but go ahead.
Kind of point of view. And here's my question for your reaction.
Yeah.
And that is, from what you know about the board and the process and the behavior of Holmes and Balwani as well, do you have an impression about where the board failed in this fraud and what things they maybe could have done? I'll expand on that for the more formal question a little bit, where what were their fiduciary duties? Is there like a moment of clear breach where they really have these problems? I can expand on that if you don't touch it, but I'm just curious, your takeaway. You study criminal frauds a lot, and there are often boards involved. So what's your take on where this board fell down and how bad is it that they did that? Is it negligent, gross negligent, should have been criminal despite the clarity we just provided?
I guess negligence is quite plausible here. Again, not good enough for a fraud claim. I'd be curious about the relative expertise of particular board members. In other words, not look at the board in the abstract. And you could be much more helpful on this than I can. But for example, in choosing a diverse board, diverse in many senses of the term, are some somewhat more scientifically equipped than others? Is that a perspective that they would bring to the board in a very, science-focused company? Not that a board member is going to oversee, the running of the lab and all that, but they're board members who could be expected, should have been expected to be more attuned to some of the very questionable noise they were hearing about the claims here. The sort of thing where, an individual board member could have said, let me call up my friend Jane, because, she's a scientist who works in this area, and I want to do a kind of quick check. Does this sound right to you? Now, that's hardly formal action by a board, but board members, I assume, are supposed to bring all kinds of wisdom and experience there. They may well have stopped and said, although she's not egregiously young by Silicon Valley standards, do we need to slow this down a little? Should we be monitoring the claims that we're hearing, even if they're not, we have no reason to think they're false, if they're just a little too ahead of themselves, if you will. I think a lot of that is possible. I will say, and this is here, in a sense, I'm changing your question. I do think, or anticipating something, I think that this verdict may have a significant effect on corporate boards, even if no board member here gets in trouble. And of course, they may still get in trouble civilly, because it's almost as if maybe this board and other boards in the past have gotten a free bite, because only Holmes is going to prison at this point. Maybe Balwani will, okay? But the next time a Holmes or a Balwani comes forth, the claim of board members that we were at worst negligent, we really didn't have any idea, those are going to sound hollow. It's as if this is a warning to not just entrepreneurs, but to boards as well.
Yeah. And I think so, to add to that a little bit, and I'm going to set up the next question for you, Bob, in the process. So I think it's easy to have, 2020 hindsight. And I think we have to be careful about that. And I also think it's easy to ask, why is it that a board fell prey to a fraud that's just so obvious after the fact? With those as caveats, it is very telling the type of board and the people on the board. And in some places in governance, we call it a star-studded board, which is not flattery, by the way. That's not a compliment. A star-studded board is a board that everyone goes, ooh, how'd they get him? Oh, wow, right? And yet when you peel it back, you will notice, and if you think Henry Kissinger, Jim Mattis, George Shultz, William Perry, like these are all impressive people. And until I get to, the former director of the CDC, none of those folks have any pedigree whatsoever in therapeutics, biotech, testing, and medical devices, nothing, right? And so some cynics have observed that there was a very particular, type of board member that she recruited. And it was men of a certain prestige and age, likely to be dazzled by her approach and style, but less likely to actually pay a lot of attention to the nuance. So one takeaway, I think, which we will address in future sessions, which I think some of the people asking questions, you're on notice. I'm going to call you for these sessions to be on the panel. One takeaway is to say, should boards reflect on their fundamental capacity to understand and assess what's really happening in an activity that requires some technical prowess to understand? And that's a question that I think is legitimate, and there is a precedent in two cases in case law that points in that direction, and it speaks to the question about where's the breach here. So the breach is possibly duty of loyalty, right? And the duty of loyalty is bad faith, and the bad faith issue arises from the fact that no one bothered to put in place a rigorous process by which they could be informed of the lab-driven critical juncture failing. So what is the existential risk to the company? That the lab process doesn't work and gives either wrong answers or no answer.
Right.
And it analogizes to what we call the Bluebell case. That's not the name of the case, but the ice cream case, where the board didn't set up a strategy to have a genuine, consistent flow of information, a program to be informed of one of the existential risks for cold dairy packed products, which is listeria. And they didn't have a plan in place, and to not have that was not negligence, but bad faith, because the lack of effort represented just a complete fall down of their efforts. So that's the world in which I think the conversations will happen for the board. But drawing on your expertise, Bob, I'd like to understand, are there red flags or things that honest, hardworking directors working with entrepreneurs who, by definition, you and I joked about this, like a lot of startups sort of follow the Ponzi scheme pattern. You say, I have this great new product and my customers love it. Parentheses, I give it to them for free. I pay them to use it. And then it does all this wonderful stuff very efficiently. Parentheses, not yet. We're kind of doing that by hand underneath the hood, but we'll get there soon. And if it's successful, we cheer them on. And if it's not successful, they kind of just fail. So there is a world in which there's a little bit of chicken egg, a little bit of leaning over your skis too much. But in that world, are there takeaways or things that directors should be paying more attention to that draw on your world, which is fraud, criminal behavior, stuff that's under the surface that isn't easy to see, but maybe there are hints popping up? Anything that is a lesson to directors in a world where you're kind of close to the line anyway, a lot of the times in startups, I think.
Well, the most important thing, and this is hardly an original insight on my part, is that a lot of this fluidity, aspiration, innovation, puffery, whatever, is something that you can associate with matters of pure finance or pure technology in the sense of internet companies where the product is human communication and so on and so on. But as much as Theranos could be viewed as that, as part of Silicon Valley, this was a healthcare device. And you've got to think of the back end, what the product ultimately does, rather than all the stuff that happens before the product goes out in terms of getting investors and persuading investors and all that. That goes to this question that a major motivation for the prosecutor, even though the prosecutor didn't win on those counts, was that this was about health. Well, two things. First of all, it was about a product, a physical product where the falsifiability of its efficacy was pretty measurable. Okay, it's not an ethereal notion. And second, that it involved healthcare. So I think stepping into a Silicon Valley company and then asking yourself, is this, the abstracted, ethereal kind of Silicon Valley company, the next Meta, whatever you want to call it, or is this a Silicon Valley company that actually in the end delivers a very concrete service and possibly a very important health-related service? I think that has to come to mind. I suppose, and I hadn't thought of this until you talked about the star-studded board. Should the stars ask themselves, okay, why was I picked? I don't know anything about this. I acknowledge I'm picked because I'm prestigious and all that. And I think I have a fair amount of wisdom at a general level, okay? But I need to be attendant to what I personally could not possibly know. And therefore, I want to see other board members who know more about this than I do. If they want to have stars like me, fine, but they need others. Or getting back to your point, one reason that I'm a star is that I've been very good at delegation. The problem is this kind of reverses itself. There's a risk that I will delegate too much. I want to delegate something to a process or a mechanism within the company, even if I can't count on other board members, which means I'll jump into this company if I know that something in the structure of the company allows for some disinterested, technologically, in this case, medically expert check on claims being made, because those are things I can't know. And getting back to the effect of this on others. Now, if you're talking about tort law, malpractice law, is always the standard of care. For physicians, it's somewhat measurable. You need to be able to be this accurate with a certain kind of medical procedure or something like that. Heck, there's legal malpractice where you can do the same thing. Nothing very systematic about this in the area of corporate board liability, but I think the Holmes verdict in a criminal case, admittedly, could be seen as raising the standard of care. And in a more general sense, it may tell board members, I've got to be much more diligent about a whole bunch of things before I go in.
Yeah. And so in a way, we're setting the table by saying, imagine the board were a better board or a better suited board. I think each of those individuals were outstanding in many ways, but as a board, they didn't have a good chance of performing their function. Right. Let me kind of take what you said and turn it into maybe some takeaways. So one, it's a good point. I think boards as a practical matter need to scope and evaluate the impact of the underlying product. Now, that's not a legalistic analysis, but it is sort of a practical one. So it's one thing to have the much hyped and promised AI scheduling assistant to book all my stuff on Sundays from 4 a.m. to 8 a.m. And for me to be like, now I got to do this, right? And I paid $25 a month for it, dang it. Versus I rely on a test that then the negative effect of it's not working makes me very ill or kills me. So those are, so boards as a natural matter need to scope their efforts and risk analysis and interventionary strategies in an early stage company based in part on that, not just that, but on part of that. And I think that's what you're saying. And I think that's really a very specific point. And then on top of that, I think you said this, and if not, I'll say it. There's sort of a trust but verify. A lot of the questions and a lot of the comments get to this, wait a minute, why didn't the board, or should they have inquired farther down the chain of command? What would have happened if they had a one-on-one with that lab director, or somehow created a conduit so they could have gotten some noise about that tension in a different way, whether a hotline or through their audit function or otherwise. And to second guess how to do it at Theranos is harder, but I think we can extract the principles, which are in early stage, high stakes. The board that's prudent has the CEO involve others farther down the line, particularly who have the knowledge firsthand of critical juncture items. That would have been the lab director or others. And then beyond that, they have a process by which they invite a flow of information that is more than just through the lens of the director. And so it appears as if the board did really neither of those things in any consistent manner, and hence sets them up for that problem. Unless you want to say anything further on that, I'll go through some of the other questions, which I think are sort of interesting.
Just one quick point, and it's actually almost more of a question to you, Dan, and that is, what about who the CEO is? You could have a brilliant scientist who's a CEO who shows terrible judgment or who actually is a liar. But at least if she is a brilliant scientist, you start with the notion that we might to some extent trust her to understand what she's talking about, okay? Holmes, I'm sure, has scientific skills, but she wasn't a brilliant scientist. She wasn't really an educated scientist. And I think that's something else that a board should think about, who the CEO is.
Yeah. And I want to highlight one other thing, which is I'm going to give the tease of an anecdote, which I will let the first person who experienced it, which is Joe Grunfest, Professor Joe Grunfest, tell the full anecdote when we pull him into the panel on the governance lessons learned for the board, follow up to this, which is to many points made in the questions and the comments. What would have been one fantastic addition to this board of directors? You had generals, you had secretaries of state, you had all, you know what would have been great? A former high profile SEC commissioner. And if you survey the landscape, it appears that there were efforts to continue to add people to the board that served a sort of optics role. And for those of you who are out in the audience who ever want to recruit Joe Grunfest, be fully aware he is a great and attentive board member. So no fraud could have been perpetrated, but he will tell the story of the efforts to recruit him and the resistance to provide sufficient detail. One of Joe Grunfest's secret weapon is his wife, who is a very talented executive in her own right and happened to come from the biotech space. And so the hard questions were not answered to his satisfaction, and he didn't move forward. And so that teases out the issue of what are the hard questions that directors and others should be asking. And I think that's what we'll end up focusing quite a bit about is questions that directors should ask, because that's one of their few powers, right? Is the ability to ask questions. So I want to switch gears a little bit and jump around and go back to something you just alluded to, which is, would the board have done better or performed differently if at the least the CEO was a highly credentialed expert in the technical innovation at hand? Not to say that it has to be that way, by the way, right? You can have great managers of people and visionaries who then bring in technical talent, but a part of that analysis is what role did gender play? And so a lot of individuals have said, well, gosh, this fraud was enabled by the vision of a female Steve Jobs, and that created the opportunity to commit the fraud. Others have said it's the opposite in some ways, which is this sort of thing, this one got bigger, but this sort of thing happens a lot and people get away with it. So my question is, how much did gender matter, and what do you think about that, Bob? Sorry about that. Internet snafu on my end, hopefully not engineered by the defense team. Go ahead.
There's such a big and complicated issue, and I'm going to waffle and say it cuts in all kinds of ways. First of all, even before you get to the legal issue, was more expected of her or was less expected of her? Was she, taking advantage of her gender or trying to avoid the disadvantages of her gender? These are big issues on which I don't have any great wisdom. I will note that there's a complexity in modern feminism itself, in which it's a profound, it's not a problem, it's just an interesting feature of modern feminism, which means where women want to gain greater status, the status they've deserved in terms of their role, let's say, in the business world, they, in a sense, aim for gender neutrality. They want to be not disadvantaged by being women, but of course there's a kind of female empowerment aspect to it, which means they will sometimes emphasize their gender. This is all perfectly legitimate. It's a complexity built into feminism. But in terms of the trial itself, everybody has a theory about this, or everybody had a theory, some thinking that the jury would go easy on her because of a bias about women being weaker or something like that. Others thought the opposite. Many people thought that the jury would be consumed by whatever prior views they had about women's rights or the role of women in the business world. I have no great wisdom on that. I'll simply offer my simplistic, instinctive impression that in the end, it just didn't matter very much. that whatever the cultural complexities of this were, this trial was not about those cultural complexities. This trial was a remarkably mundane, legally mundane, although factually, bizarre instance of fraud, period.
And I'll end with a question that you can take wherever you want, and then I'm going to give you last word on top of that. And that is, there are implications, therefore, for entrepreneurs, perhaps for women entrepreneurs or entrepreneurs that want to elevate their visibility as a part of their strategy for success for the company, which is something that Elizabeth Holmes did. And there's implications for entrepreneurs, but then there's also a concern and implications for entrepreneurs that maintain complete control as a matter of governance within their company, where the board is never irrelevant. The control by the entrepreneur does not negate the fiduciary duties of the board. It makes it very hard in practice to exercise those duties, arguably. But so where do you think the views of whether it's your type of expert, which is criminal that looks at things in corporate world, or corporate players or venture capital, where do you think the changes will appear, if any, as a result of this? Will there be changes about how women go about forming companies and being visible? Will there be changes about how we do or don't cede as much control to entrepreneurs? Or do you think these are things that are outside of the control and we'll just see this story repeated again and again?
Well, you asked a number of questions there. I don't have any wisdom at all on the gender-specific implications of this case. I do think that this was a case about hubris, and that one possibility is, and of course, the clearest deterrence, if there is any, is don't make flat-out lies in the face of investors the way she did. See, you can become a federal felon when you do that. In a somewhat more nuanced way, maybe it will induce some entrepreneurs who are morally honest, but who might recognize that they have a tendency to hubris, to try to be a little more self-critical, to be a little more self-skeptical, because although they maybe in most cases would never dream of lying, they should be aware of how the aspirational aspects of Silicon Valley can get out of control, and therefore don't create a board just to be there to have a board. Yes, it has legal responsibilities, but I'm running the company. But actually find a board that could be a council of wise people in some ways.
And I think that highlights a thought experiment we often have in corporate governance, particularly for high value, high growth startups. And that is, everyone has their, Aunt Gina. I have an Aunt Gina. She's from the Midwest. She's an aunt-in-law, I guess. But she, she's retired elementary school teacher. She's very well educated, but she's not caught up in Silicon Valley, and she kind of has clear insight that I often find among Midwesterners, friendly but pointed. And she asks questions like, "I don't get it. Why is," and fill in the blank, or, "Well, that's an answer that isn't an answer, dear. When will she answer the question?" Should we all have an Aunt Gina stuck somewhere, either in our personal board of advisors or on these boards? Like, how do you achieve the solution to what you just described as hubris or overconfidence?
I'll use a pompous, not very uncorporate term. The relationship should be dialectical in some way. I think it should be. I think that's where the hubris is corrected, if you will. And I realize the Platonic dialogue doesn't seem to map on very well with what happens in Silicon Valley offices, but there we go.
Yeah, that's a bigger culture discussion, which we'll have to shelve for a future conversation. Any last word, Bob? Thought, takeaway?
I just want to say I resist the notion that this wasn't worthy of criminal prosecution because everybody does it. There is certainly an argument that this isn't the proper place for criminal law generally, that this is the sort of thing that should be handled by the civil system, which does very well in terms of deterrence and so on and so on. And I think that's a plausible argument. But once we have fraud laws, which once they're going to be applied, the notion that you don't do it if this is a kind of anomic world where nobody believes what anybody says anyway, number one, I just don't think that's true. I think that's a caricature, oddly in a perverse way, a self-congratulatory caricature of Silicon Valley. And second of all, it underestimates the power of criminal law to change this thing called culture. And last point, if I have this moment, could we lose the term culture in Silicon Valley culture? Culture used to be about art, music, history, whatever. This isn't culture. This is sort of sociobiological behavior. And sociobiological behavior is, to some significant extent, alterable by criminal law.
That is a great spot to end. So I'm going to end it there. I'm going to say thank you very much, Bob.